Specifically, the section that we're talking about is 15.2.17, investigated detentions. It says, an officer is permitted to stop and briefly detain a person for investigative purposes if the officer has a reasonable suspicion supported by articulable facts that criminal activity may be afoot, even if the officer lacks probable cause. Such encounters must be evaluated by considering the totality of the circumstances. Investigative detention should last no longer than is necessary to effectuate the purpose of the stop. The investigative methods employed should be the least intrusive means reasonably available to verify or dispel the officer's suspicion in a short period of time. Any investigative detention must conform to current law. I want to bring your attention that one of the current law that's applicable here is one of the attachments here. Well, there's several attachments, but the one I'm going to reference is Florida Statute 901-151, which is Florida Stop and Frisk Law. Okay, are you familiar with that?
We just read it.
Okay. So that being said, based on the facts of this incident as reviewed in this investigation, do you feel that you violated Policy and Procedure Directive 15-2 regarding that investigative detention?
At the time, I did not. Looking back at it and being peeled apart, yes, I should have investigated further, and if he wasn't going to move off the sidewalk, he doesn't have to move off the sidewalk. We could have taken the investigation inside the establishment, since they were the complainant anyways, and figured out what went down. And then afterwards I find out that Galt had already done all this, but I wasn't made aware of any of it.
So knowing what you know now, that the investigation has bared out, like I told you at the very beginning, the record is undisputed of what was said, what was done, and by everyone involved on video and audio. So knowing all that, and knowing now that there isn't any panhandling ordinance, there was no crime being committed, the investigation bore that out. If I'm understanding you right, with that fact, would you agree that the intent of the investigative detention was violated?
Yes.
Okay.
But if I had the knowledge that I have now, I would have never done that. Call would have went completely different.
Well, you have resources to tap into that knowledge. One, you can call your supervisor, right? Always. Two, you have access to MuniCode via your computer. You could check and see if panhandling is a violation or an ordinance before you even get there. Property issues can be checked on the property appraiser's website. Have you ever used that?
Yeah,
For
I'm
property
not,
lines? And,
yeah, I mean, I knew the property lines.
Yeah. Okay.
But I'm not disputing the fact